Hey, welcome. Employment Law Show. John Scholes and Lior Samfiru. Welcome to the show. A lot of stuff to cover today, including termination of employment, setting the record straight. We will do all that. Get to some of the phone calls from our long-running radio show as well. Anytime to reach out, employmentlawyer.ca. I was going to do Severance show there for a second, but that's coming up later on. The number 1-855-821-5900. That is anytime, and you want to go to pocketemploymentlawyer.ca. That is literally like having a little lawyer in your pocket at all times. It's free, it's anonymous, and there is contact at the top of that as well. But before we get into all kinds of stuff today, Lior, including phone calls, a lot of things to cover. Week that was, what's happening in your world?
Hi, John. Great to be here and great to be back and talking about employment law and workplace rights. And we're going to focus on a lot of things that are so important for individuals right now because our jobs have never been more precarious than they are right now. Our job security, our workplace rights. So it's so important that you know what your rights are. If you're off work, on a layoff, if you're being called back to work, what happens if you're not being called back to work, or if your job changes? All those things and more. We're going to try to talk about this on the show like we do every single week. And this week, we're actually going to focus a bit more even on termination of employment because I've been speaking with so many people who are not being called back to work or having their employment terminated. So I want everyone to understand what you're owed if you're let go, how that's calculated, and what to do if you lost your job. And of course, if we don't cover your specific situation here, or if you want to talk to me privately, we'll give you my contact information throughout the show so that we can connect, so I can help you and we can go over your matter. There's no such thing as a bad question. There's really only answers and solutions. But I always like to start off with the situation that came across my desk just very recently. I spoke right at the beginning of the week with a gentleman who was called back to work from his layoff. So he'd gone in first day and noticed right off the bat that there's no social distancing. There is no measures taken to make sure that employees are safe. Employees were huddled together even to get into the building. It was not at all what the government said businesses must do. Well, the next day, he texts his employer in the morning saying, I'm not comfortable coming in until I know that the workplace is safe. His employer says, well, you have to come in. We're allowed to be open. You're expected to be in. If you don't show up, we'll consider you to have resigned. The next day, he gets a message from his employer. We accept your resignation. You're not working here anymore. Well, he calls me and he wants to know, well, did I do something wrong? I thought I had a right to be safe. My employer wasn't protecting me. There was no social distancing. Well, what gives here? So, John, this is something that's so important to remember because we all have a right to work in a safe workplace. Now, that's true always, not just in a COVID-19 situation, but it takes a unique meaning right now when we talk about safety in the workplace. Your employer has to do whatever the government said in terms of ensuring safety, ensuring social distancing, limiting the number of people in the workplace. They have to do all that. No exceptions, no excuses. And an employer that doesn't do that, that employer should not be open. Well, in this situation, he did not resign this individual. He had absolutely every right to refuse unsafe work. He absolutely did. So what does that mean? It means, number one, his employment is being terminated. So he's owed severance. He's been there for over 14 years. He's going to be owed over a year's pay. There could be additional damages because his employer treated him in a very bad way when all he was trying to do is ensure that he is safe. So I wanted to remind everyone there that you cannot be terminated or considered to have resigned if you're standing up for your right to work in a safe work environment. That said, if your employer has ensured safety, if your employer has taken all precautions necessary to ensure social distancing, etc., yes, in that case, you may be expected to go to work, and if you don't, that could be a resignation. If you're not sure what to do, if you're not sure what your situation is or whether you should be going back to work, don't hesitate. Reach out to me anytime.
That number, by the way, 1-855-821-5900. Help at employmentlawyer.ca and the website employmentlawyer.ca. That is where you will catch a resource for our radio show, which we've been doing for about 8 or 9 years now. It's been a good run, and we take a lot of phone calls every week on the radio show. We'll play our first call from the radio here right now.
I've been temporarily laid off, and if my employer does not end up calling me back because the situation doesn't improve, let's say, at what point am I entitled to severance at that point or holiday pay?
How long have you worked there for?
5.5 years.
And what kind of a job and how old are you?
I am almost 60, and it's an administrative position, I guess.
Right, and this is probably, John, one of the top questions I've been getting over the past few weeks, in the sense that employees are being called back to work. Some are not, and those that are not are wondering, well, what does this mean for me? What is my status? So depending on where you are, a layoff would last for a certain period of time. For example, in BC, it could last right now up to 16 weeks. In Ontario, depending on whether you have benefit coverage or not, anywhere from either 13 or 35 weeks. Bottom line, though, if your employer chooses not to call you back, or maybe they can't call you back for business reasons or financial reasons, even if they have a good reason not to call you back, that is a termination, automatically a termination. You're automatically owed severance. So if you're not called back to work, follow up with your employers, understand what their plans are. But if the idea is that either they don't know or you're simply not being called back to work, it's time to think about and consider severance. And remember, we'll talk about this more on the show. Severance is significantly more than a week per year of service. So we know this lady that called us on the show. We talked about, we heard her information. Let's take her information and let's plug that in to pocketemploymentlawyer.ca to see how much severance she's actually owed. So we know she's in an administrative role, been there for over 5 years. She's 59 years of age. Well, someone in her situation is owed right around 6 months' pay. Depending on how much she earns, obviously that's going to be a few tens of thousands of dollars. 6 months' pay. And what I just read, what you saw on the screen, is from pocketemploymentlawyer.ca. That's how easy it is to find out how much compensation, how much severance you're owed if you lost your job. It takes seconds, and it's so important right now to do that. If you're sitting at home wondering, hey, am I getting called back? Is my employer going to call me back? If you don't know, if you want to be prepared to understand how much you're owed, just go to pocketemploymentlawyer.ca, find out what you're owed.
Yeah, it's a good way to set the table for the next part here, and it is from pocketemploymentlawyer.ca. Again, completely anonymous. It's absolutely free and full of information. If it's the middle of the night, you can't contact Lior, you can go to pocketemploymentlawyer.ca or send an email through it as well, which we will get to right now. This one comes from Tristan, says, I've been recalled to work. Unfortunately, my hours are being cut from 30 down to 15 hours a week. My boss said that it is only temporary during the pandemic, but I don't believe her. What are my options?
So here's the thing, John. Our regular viewers know this because I've said this many times. An employer does not have a right to change significant terms of employment. They don't have a right to reduce you from 30 to 15 hours a week. They don't. Now, that also applies in a COVID-19 situation. Even though we do have this unique situation, this pandemic, it's still the same law. It's still the same rule. If your employer chooses to treat your or to change terms of employment, you now and the employee have a choice. You can accept it, of course, and now in this case, working 15 hours a week, or you can treat that as a termination of your employment. Again, call that a constructive dismissal, and get your full severance. So anytime you're looking at a pay cut that's significant, a change in hours that's significant, a change in work location, a change in responsibilities, you have to start thinking constructive dismissal. So let's take the situation, 30 hours reduced to 15. Let's plug that into pocketemploymentlawyer.ca, because in the pocketemploymentlawyer.ca, there's a tool that allows you to find out if, in fact, you've been constructively dismissed. So if we take that information and we apply it in pocketemploymentlawyer.ca, we see that she's been working there for 3 years. What her employer did is changed her hours. This has not happened before. And you can see the result there right at the bottom says that a change in hours like this is a significant change and does result in a constructive dismissal. So you can use pocketemploymentlawyer.ca yourself to find out if your situation, if whatever your employer did rises to the level of constructive dismissal. And keep in mind, regardless of all of that, if your employer changes your pay, even if it's a COVID-19 situation, that's not something an employer is allowed to do. You do have a right to treat that as a constructive dismissal.
Now, this person's obviously, 30 down to 15. They've taken a 50% haircut. That's a big one. Now, what are the pitfalls that they say, you know what, I really like working here. I want to be a team player. I want to take one for the team. Maybe I'll do this for a little while.
And I've been getting that often. I understand. I feel bad for my employer, and I get that. And I'm not saying that's a bad thing at all, but there is something else you have to keep in mind. There's actually two things. Number one is if you're going to take that pay cut, there's no guarantee, unless there's an agreement in writing, there's no guarantee that your employer is actually going to bump you back up to what you used to be. So you may think, okay, it's a COVID-19 situation, I'll take the pay cut. As soon as we're out of this pandemic, I'm going to increase it back, or I'm going to have my employer increase it back. No. Once you've accepted it, there's no obligation on the employer to increase it back. So that's problem number one. problem number two gets even worse is by allowing your employer to cut your pay this one time, you now have given them the right to do it again. And the second time they do that, or third or fourth, you won't be able to do anything about it. That's why it is something you at least have to consider. Do I stand up for my rights? Do I treat that as a constructive dismissal? Because if I don't, it could be an opening for the employer to do all kinds of things in the future that otherwise they would not be allowed to do.
And if this person is brought down to the 50% pay, that goes on for 3 or 4 months, and the employer says, you know what, I'm really struggling, I'm going to let you go. Are you now not basing your severance on that reduced amount?
But wait, it gets worse, as they say. Yes, you're absolutely right. So you accept the pay cut and you work a month, 2, 6, whatever it is. Now the employer says, well, I'm going to have to let you go. Well, because you accepted that pay cut, now the severance is going to be calculated on the reduced amount. So again, you lose even more compensation, more money that legally you would otherwise have. So if you're going to lose your job, you want to lose that job making as much income as possible than less income, because that's going to reduce your severance.
I think the legal term is a big bowl of wrong, so you don't want that to happen to you anytime. We're going to take a quick break here, and when we come back, termination of employment, setting the record straight. So stick around for it. You want to call in to Lior anytime, 1-855-821-5900, and employmentlawyer.ca as well. Right back.
You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.
You've been denied long-term disability. You think you're powerless, but you have a lot more power than you think. I'll tell you a secret. It's a numbers game for the insurance company. They're betting on you walking away from money that they owe you. Don't make that mistake. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
And welcome back. Employment Law Show. John Scholes, Lior Samfiru, reaching out. You can do that anytime. And go to pocketemploymentlawyer.ca. That is a completely free website. It is anonymous, but if you want to contact Lior and the crew after that, there's a yellow button at the top right. You can do that and send an email as well. Okay, termination of employment, setting the record straight. Let's get right into these because this is a very hot topic, especially in the current employment climate. Lior, first one is your employer can let you go. They can let you go even if they don't have a good reason.
It is such an important thing for all of us to remember this, because one of the main questions I've been getting for years is individuals contacting me upset because their employer is letting them go. They don't believe the reason is legitimate, and they ask me, well, how can this be legal? Can my employer do this? So let's be very clear. An employer generally is allowed to let you go pretty much for any reason. There's exceptions, which we'll talk about, but generally, your employer can let you go for any reason as long as severance is paid. Now, you may not like the reason they give you, and maybe you even are able to prove that the reason is wrong, it's false. Regardless, as long as full severance is paid, your employer can do that. And a common situation may be, well, employee, we're cutting costs, or we're letting you go. All the while, you know they're hiring other people, so clearly they're not cutting costs. Regardless, as long as severance is paid, it's not going to make you happy. I'm not even saying it's fair, but legally that can happen as long as severance is paid. Now, where we hear this term wrongful dismissal actually, for the most part, has nothing to do with the reason your employer lets you go. It has to do with severance. A situation where you've been let go and have not been paid proper severance, that is a wrongful dismissal. When you're owed a certain amount and the company's paying less or offering less, that is a wrongful dismissal. And keep in mind, over 90% of people, in fact, are wrongfully dismissed. They're offered less severance that they're owed, but your employer generally can let you go as long as severance is paid.
Next one up is this, pal. That is, your employer can't fire you simply because they don't want to accommodate your disability.
So I said that there are exceptions. So your employer cannot let you go for a discriminatory reason, for example. So you cannot be let go because of your age or ethnicity or race or disability, etc. Now, that also applies in a situation where you may have a medical condition, for example, and you require accommodation. The employer can't say, well, you know what, that's too much of a pain to accommodate you, to give you modified duties, so we're just going to let you go. That would be illegal. Your employer cannot do that. That's a human rights violation. One of the most fundamental rights that we have as employees anywhere in Canada is the right to be accommodated if we have a medical condition. Modified duties, modified hours, maybe ability to work from home. As long as you have something from a doctor saying that you need accommodation, your employer has to make all efforts to accommodate. It's not up to them, even if it's not easy. Even if it does cost the employer money, they still have to do that. So if you think you're ever in a situation where you need some accommodation, your employer doesn't want to do it, refuses, not trying hard enough, that could be a human rights violation. You want to reach out to me as soon as possible. You cannot be let go just because you have a medical condition. You cannot be let go because you seek accommodation.
We are setting the record straight about termination of employment. The third one is this: a temporary layoff, as we discussed, is essentially a termination.
And I've seen jaws drop for the past few months as we've been dealing with the pandemic when I've been saying that. Are you saying that even though 70% of people may be at some point now on a temporary layoff, it's illegal? Yeah, it actually is. An employer, for the most part, does not have a right to lay you off temporarily. And what I mean by that is it becomes essentially a termination. If you've been laid off temporarily, you can treat that temporary layoff as a termination of employment. Even though your employer is not saying, I'm letting you go. Your employer is simply saying, I'm doing this temporarily. Fine. You still, as the employee, can treat that as a termination and require the company to pay severance. And one of the reasons you may want to consider doing that is if you decide to accept the layoff and continue waiting at home and then go back to work when they call you back, is by accepting it, you've given the company the right to do it again. And the next time you do that, you may not be able to resist. You may not be able to treat that as a termination. So something to consider. But for most people, John, a temporary layoff is, in fact, a termination.
You know, this next one is part of the reason why you started the radio show all those years ago and this show on TV as well. And that is, you know, don't go to the Ministry of Labour if you've been let go. Do not go there.
No. So in Ontario, Ministry of Labour, and BC, the Employment Standards Branch, you cannot go there if you lost your job. You can go there for other things for sure. Overtime issues, vacation pay issues, holiday pay issues, absolutely yes. Not if you lost your job. The government can only enforce and even advise you with respect to your minimum termination entitlements. Those only form a small fraction of what you're actually owed. So if you call the government and you say, okay, I've been working for an employer for 4 years, what am I owed? They're going to tell you 4 weeks. Don't believe me? Call them now. Try it. 4 weeks. In fact, you could be owed 8 months pay, 9 months, even 12 months pay, not weeks, months. The difference could be massive. So let's use another example. I've been working for 4 years. My employer offered me 6 weeks pay. I called the government. They say 4 weeks is all you're owed. I'm thinking, okay, well, they offered me 6 weeks. The government said it should be 4. So I guess I'm good. I'll accept it because it's more. In fact, not only is that wrong, you could be owed 9 months' pay. And when you realize that's the case, it's too late. So what do you do instead? You go to pocketemploymentlawyer.ca. You find out the actual amount in seconds. I do mean the seconds. And completely free and completely anonymous. You call me. I'll tell you what you're owed. You don't like me, call another lawyer. But you do anything other than contact the government when you lost your job. Very important.
Next one is this: severance is not based on what your former employer or about to be former employer wants to pay you.
Right. Your severance has nothing to do with what your employer wants to pay you or thinks you should be paid. The law is the only one that determines how much you're owed. And remember, some general rules. Your entitlements, your severance is based on 3 main factors: your age, your position, and the length of your employment. And the longer you work, the older you are and the more senior a position you have, the more severance is owed to you. So those are the factors. And if your company thinks it should be 2 months, it doesn't matter. The law will make that determination. And John, I've said this before. I speak with people that have lost their job every day, 7 days a week with no exceptions. Well, in 90% of these cases, 90, The individuals that have been let go, they're holding their severance letters in hand, are offered significantly less than what they're owed. And I'm not talking about the fact that, oh, it should have been 6 months and they were offered 5. I'm talking about it should have been 6 months and they were offered 3 weeks. So that's how important it is to get some advice. The employer doesn't decide that, the law does. And because the law decides, it's also easy to resolve these issues because the law tells us all we need to know.
You know, we're talking about setting the record straight on termination of employment, and you mentioned, you know, severance offer in hand, and that's good for the final point. You do not have to sign it, your severance offer, termination offer, whatever you want to call it, on the spot. Don't let them pressure you into that.
Not only do you not have to sign it on the spot, never sign it on the spot, but not only that, you don't even have to sign it by the deadline that the company puts in there. So you'll see a deadline, you need to sign by Friday at 5. Don't worry about that. Forget that deadline. I'm sitting here on TV telling you, you can ignore that severance deadline because it doesn't matter. Your legal rights don't expire on the deadline at Friday or Tuesday or whatever the date is. Your legal rights are what they are. Either you're owed something or you're not. And if you are owed something, you have 2 years to pursue that. I'm not suggesting you wait 2 years, not at all. But get the advice that you need. Think about it. Go to pocketemploymentlawyer.ca, and if you can't do that before the deadline, ignore it. Once you sign, even though you may have felt the pressure, even though you were not in your right state of mind and you felt that your employer was misleading you, once you sign that, still you can't get out of it. So pocketemploymentlawyer.ca, again, is your friend. So am I. But no matter what, don't be intimidated by that deadline.
Employmentlawyer.ca, that's the place to find the radio version of this particular show and details how you can catch that each week, which you have been for years. We play the phone calls back from it. Phone call number 2 is coming up right now.
I worked for about 2 years. When I began work, I asked for accommodation and was immediately put on short-term disability. I was denied long-term, but then given a position which I was subsequently unable to do because of my disability and need for accommodation. I was put on short-term disability again and have just been denied long-term disability for the second time. Wondering if there's anything I can do.
Well, you understand the absurdity of the situation, John. On the one hand, the insurance company is saying, oh, no, you're not disabled enough. You should be able to go back to work. On the other hand, the employer says, no, we don't have work for you because you're too disabled. That's absurd, but as absurd as that is, that happens often. It really does infuriate me because here we have someone who is clearly not well, someone that would love to work but can't, and now no one wants to take ownership of the situation. So it has to be one of those things that either he is unable to work, in which case the insurance company has to pay him. That's why he has disability coverage. Or if he's not disabled enough not to work, then his employer has to allow him to work. The company can't say we don't want to accommodate. So the first thing I would do here is I would deal with the insurance company and find out, first of all, what does his doctor say? If his doctor says he can't work, the insurance company should be paying. If he is able to work with accommodation, the employer has to accommodate him. Even if they don't want to, even if they think it's too hard or a bit of a pain in the butt, they have to do it. Someone has to pay this individual. And if you're out there at home and your insurance company, your disability insurer is giving you a hard time, your employer is now threatening you, let's end the suffering. Reach out to us. We can deal with both the insurance company and your employer. One or both of them are going to have to pay you the compensation that you're owed and take ownership of the situation. They can't deny you. And if you're in that situation, reach out right away.
You bet. Coming up here, we'll take a short break, and then it's the right to refuse to return to an unsafe workplace. We'll navigate that one as well. 1-855-821-5900 and employmentlawyer.ca. And lots more. The Employment Law Show is on the way.
You were being harassed, and when you said something about it, you're the one who lost your job. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Insurance companies deny long-term disability claims all the time. They give lots of excuses. Don't give up. I've seen it all. They've ignored your doctors, they've ignored you. You're angry and you're frustrated. But there's hope. We resolve disability claims all the time. We force insurers to pay what they owe. We're in your corner.
Call Savan and his team, 1-855-821-5900, or go to disabilityrights.ca. You thought you had a secure job. You didn't see it coming. Now what do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca.
Welcome back. Employment Law Show. John Scholes and Lior Samfiru. You want to reach out anytime. You know that phone number by now, 1-855-821-5900. You can also anytime go to pocketemploymentlawyer.ca. And our radio show has been for about eight plus years, and we take the phone calls from it, as you know, playing back here. I think this is phone call number 3 coming up now, Lior.
I've worked in the hospitality management for 29 years and lost my job when we had to shut down the business. Still have no employment and no future return date. Curious if I qualify for a severance.
The business is closed because of the virus, but I guess the plan is to reopen it. Is that right?
Yes.
So, yes, of course you are owed severance if now you don't have a job. And after all these years, 29 years, we're talking about a substantial amount of severance. So this may happen to you. Your business is not coming back. They've decided to shut down. They don't know. In the meantime, you're kind of left in limbo. One of the options you have, and you don't have to wait for your employer to make the decision for you. You can make that decision, is to get your severance. So rather than me tell you how much severance this person is owed, it's a lot. Let's plug that into pocketemploymentlawyer.ca and find out. Again, it's easy, it's anonymous, it's free. So we see right here that she's been there for 29 years. That's a very, very long time. Let's say she's 55 years old. I just picked an age. And in this situation, as a middle manager, she's owed, as you see on the screen, 24 months pay. 24 months. That's a lot of time, a lot of severance that she's owed. And that's how easy it is to find exactly what you're owed. You may not be owed 24 months pay. You could be owed less, but it's still probably a substantial amount. Don't believe me, try it for yourself at pocketemploymentlawyer.ca.
Want to mention as well, anytime you want to reach out to Lior and the team, terminationquestions.com is a great resource for you. And I'll get to one from that website now. Lior, Jill writes in, says, I will likely be recalled to work in a few weeks. I have heard from coworkers already back at work that our boss isn't following any of the rules set out by public health. Can I refuse to return to work?
John, I said right at the top of the show, because it's that important, that you and I and all of us have a right to work in a safe work environment. There's no exceptions to that. And it's so, especially now, important when we have this pandemic, we have this virus going around. We don't want to, and we should never expose ourselves unnecessarily to this virus. So it's important that your employer comply with its obligations. Your employer has to comply with all regulations in terms of social distancing, etc. So what do you do in this situation? If you're not sure what your employer is doing, ask the question. Call your employer, email your employer, and ask the question, what have you done to ensure safety? It's a legitimate question. There's nothing wrong with it. You know, tell me what you've done in terms of social distancing or limiting the exposure to the public. Ask the question. If your employer refuses to tell you or doesn't answer, honestly, you shouldn't be going to work because you're potentially risking yourself. If your employer responds and doesn't give you a satisfactory answer, follow up. Ultimately, you have a right to refuse unsafe work. You have that right. And not only do you have the right, you should do that, because if you continue working in an unsafe environment, you're putting yourself and others at risk. And that's the worst thing that can happen. So remember, you can refuse unsafe work. In some situations, a member of the government may have to come in to investigate the workplace and determine whether, in fact, it's safe or not. That inspector will make that determination, and if they can shut the employer down if they need to. So if you're not sure what to do, if your employer is putting pressure on you, reach out to me, but you can and should refuse unsafe work.
And just before we go, again, temporary layoffs, it's going to be huge now, will be for the next few months at least. Don't accept it if you don't have to, right?
Don't accept it if you don't have to. Think about what's best for you, but certainly, if it's now time when that layoff is over and you're not being called back to work, or you're being called to a different job or a different pay, reach out to me. You're owed compensation. I don't make that decision. The law already has made that decision. We can help you get that compensation. No one's going to stand up for your rights other than you. Reach out to me and I'll help you do that.
And remember, pocketemploymentlawyer.ca, employmentlawyer.ca, the website, and the phone call, of course, anytime, 1-855-821-5900. Use it all. Reach out. Don't hesitate. We got lots more in future shows, so stick around for it. We'll catch you next time right here, Employment Law Show.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.
You lost your job. They said they had a good reason, but you think you've been wrongfully dismissed. Now what are you going to do?
I'm going to employmentlawyer.ca.
Always check with the employment lawyer first at employmentlawyer.ca. You lost your job. They only gave you 2 weeks of severance per year worked. But where can you find out what you're really owed?
I'm going to severancepaycalculator.com.
Find out how much you're owed right now. Severancepaycalculator.com.